These Creditors in Commerce workshop sessions, hereinafter sessions, are the private exchange of ideas and concepts between the providers and the recipients. The content is not meant as legal advice. The use or attempted use of any idea or procedure discussed in these sessions, as applied to the recipient's own personal transactions, cases, or controversies, or applied to other cases, may or may not result in a favorable outcome or the same outcome as discussed in these sessions. Each transition or transaction, case, or controversy may be different as a result of unique actions or unique statements made by the parties therein, and each different act or statement in any transaction affects or may affect whether any procedure or idea discussed in these sessions is relevant to the recipient's transactions or that the outcome thereof will be depicted as in these sessions. The discussion of ideas or procedures in these sessions is not exhaustive of the subjects being discussed. Many ideas and concepts that can affect the outcome of any legal or commercial procedure are not discussed in these sessions, and the fact that the recipients may not be aware of these issues may have an adverse effect on the outcome of the recipient's procedures. It is the responsibility of the recipients to understand their own transactions and to apply the appropriate and complete concepts necessary for a procedural and substantive remedy thereto. These sessions may be redistributed privately by any recipient to another recipient requesting them, condition upon the fact that this notice is provided therewith. If you have any questions, you may contact Creditors in Commerce by email at harmony@creditorsincommerce.com.
We're going to lay out one foundation you need to know. Since everything is in contract, first thing you got to determine in the contract, the parties. If we don't know who the parties are, we have a problem. Second thing you got to do in the contract is you got to determine what is the jurisdiction or the venue of that contract. What law is going to determine the details, the solutions, how are we going to resolve problems if one comes up in the contract?
And keep in mind that is, as any element of a contract, movable.
Correct.
Because I've received public contract offers, which I immediately moved into a private venue by returning the contract privately. For instance, a summons and complaint I recently got. That's a public side contract. I moved it into the private. And the first thing I did was identify all the parties to the contract, because I took every name off of that document. Not only the plaintiff, but there were 3 U.S. attorneys named on that document. So I assumed they must have an interest, right? If you're going to put your name or a title on there, there must be some kind of an interest there. So I made my contract with the plaintiff and the 3 attorneys. So there were 4 parties besides the 3 parties named as defendants. Was I a party to that contract? No, not initially. See, I entered into the contract in my private trust capacity. My capacity to privately contract and my capacity to be the paramount security interest holder over the defendant's property.
Well, how did you move it from a public summons into the private side? What did you do?
If I'd have responded through the court, that would have been public contract.
You mean if I'd have sent an answer back to the clerk of the court?
If I'd have sent an answer to the complaint into the clerk of the court, I'd be playing in public contract.
Well, who'd you send it to then if you didn't send it
back? I sent it to, the people I sent it to were the 3 U.S. attorneys in their private capacities, meaning I used registered mail, $21 of postage, named them personally, care of their professional addresses, named them personally in the contracts, and then the plaintiff, which is a fiction of law, United States of America, I sent it to their attorney, the Attorney General of the United States. So those were the 4 parties that I privately contracted with, because the United States is a fiction of law. It has no capacity in private contract. So I have to go through its private phase. Who are the three parties that must expatriate in order to serve their roles in the United States? Secretary of Treasury, Secretary of State, and Attorney General. So I went through the private capacity of the Attorney General to affect the private side of the United States.
So what'd you do? Address it to his name, Attorney General so-and-so, or just his name?
I just put his name. Typically, I don't use titles because they're public titles, unless I'm unsure of the identity of the party I'm dealing with. Like, for instance, if I'm unsure of the CFO of a bank, but I found it published somewhere, I still can't be sure that that's the current CFO of the bank. So I may put the name, who I think it is, and then put Chief Financial Officer, which would then make his successor liable on the contract. And I may even reference that in my contract, that this is, any successors, that if the current Chief Financial Officer...
Could you just put his private name in a / / Virgil Chief Financial Officer?
I'd probably put comma, like an alternate designation.
Did you consider doing business as DBA in front of his title?
You could, and there's nothing wrong with that. I didn't do it. I don't do that. I've done it before, but not something I feel necessary to do. Like I said, it's a private contract, so you can name them how you want to name them. The important part is getting their agreement in the process. And I got all four parties to agree to every step of my contract. So I got to establish by consent several facts, including settlement of the contract. So and then once I've completed that process on the private side, that private contract, because it's a private contract, I brought it into the court, but on the private side of the court. So nothing actually went into that court case on the public side in regards to that contract, because I did a private settlement. And then I brought the private settlement into the private side of the court case. Otherwise, the only way I can be recognized in the public contract is under the public trust, which the public trust was a debtor. And in my private capacity, I'm the paramount security interest holder. My private trust is the paramount security interest holder in the public trust. I am neither. I'm merely the executive trustee of these trusts. So my private trust is an upper lowercase appellation of the name. My public trust is all uppercase name, and I am the executive trustee of both trusts. And actually, there were three defendants, and I'm the executive trustee and paramount security interest holder in all three defendants. So, in reality, these are fictions, right? Both the private trust and the public trust. I could enter a contract as Gordon Hall. Is there anyone here who can rebut that I have a paramount security interest in the property of Gordon Hall?
Might be talking about a different Gordon Hall. I don't know.
It could be. But the fact is that so often you want to get attached to the Brandon Adams, that's the me trust. No. Like I told a story last weekend. I'm doing a mastery in commerce course in LA, and it's a 7-month-long course. And I was reminded of an episode of my life where when I first moved out of my house, I lived with this family. And they were a small family, mom, dad, and son. And the son, when I was living with him, he was maybe 4 years old, maybe 5 years old. He was young. And he always referred to himself in the third person. He's like, Ian's hungry. Ian wants this. Ian wants that. And it was always kind of like a joke, he never says I or me. And this is one of the ways that when you read, and this is actually there's actually a maxim of law that identity is established in a multitude of ways. That by merely saying that you're not the name doesn't establish the identity. By saying you're the name doesn't establish an identity. But when you're entering into contract and you're asserting that you're not this public trust, and then you start referring to I and me, you've just identified yourself as the public trust. And so it'd be a good practice for all of us to start thinking like little Ian did and refer to the defendant or the taxpayer. You see? Because it's not you. And don't get confused and use those words of me and I. Well, I paid the tax, or I filed a this, or I filed a that, or you charged me, right? You have to get in the idea that you're not either of these. You're not the upper lowercase, you're not the uppercase. Refer to them as separate parties from you. In my belief, there is no title I attach to me. Brandon Adams, upper lowercase is not me. Brandon Adams, all uppercase is not me. None of those appellations are me. So when I refer to them in their capacities. I'm here representing the paramount security interest holder, the private trust. Am I the paramount security interest holder? Nope. So I don't even refer to myself as the paramount security interest holder. I say, well, the paramount security interest holder has a this or has a that, if I make any assertions. Well, the defendant did this, the defendant has that, and the paramount security interest holder has a paramount security interest in the property of the defendant or the taxpayer. So I'm referring everything as third person. There is no me or I.
Listen to an attorney in court.
Yeah, my client.
He says, I am here today, Jim so-and-so here today on behalf of the defendant Gordon Hall. And then he refers to everything, the defendant this, the defendant that. That's what Brandon's telling you in the simplest terms. Remember, a name technically is nothing more than a word by which a person or thing is known. And a word is a speech sound or series of speech sounds that communicates a meaning. So how can you be a speech sound? You're not. You don't live in California. You don't live in the United States. Any of that stuff. You can't live in a word.
The system therein is admiralty maritime equity as opposed to common law or the republic, in that the rules of evidence are no hearsay is permitted. However, all their other rules are the following. First exception to the hearsay rule. Second exception to the hearsay rule. That's basically the rules of evidence. Did you hear any rule of evidence that wasn't hearsay? Every evidence in their system is hearsay. What does hearsay constitute? It constitutes speech or evidence coming out of someone that is not the real party of interest there. And so in their system, you do not ever have first-hand testimony. You don't go in there and say, I did this, or I am that. You go in and speak in the third party. Well, the defendant you're looking at is, so that you are not speaking in the capacity of who you think you're defending. You got to be apart from that, or else it is not recognized in that court. So now we get back to what I started the session with, which is basically if you don't understand contract law, the fundamentals, you can't do this. And the first thing we have to do is we have to state who the parties are. The second thing, which is very important, is the jurisdiction of this contract. So let's look at a court scenario. Let's say we're on an arraignment for anything, and the first thing the judge says is, what is your name? He's looking for a party, is he not?
Yes.
And if you identify with the name on the charging instrument, if you say, that is me, you have now become the debtor in this case.
What if you say it's not me?
If you say it's not me, then he's going, well, sit down and get out of here, or I'm holding you in contempt. We're looking for the name on that ticket.
Well, I could say the defendant's name is this, and I am here representing the interest of a paramount security interest holder in the defendant's property.
Now, what did Brandon just do? Didn't he introduce a new party into the contract that was never there before? And the only way you can get your remedy is to understand that no one that's named on their offers has a remedy, because they're all debtors. Can a debtor ever pay off a claim? If you can't pay off a claim, why are you there in the capacity of someone that has no ability to get a remedy? Don't they say, well, you're representing yourself unless you want us to appoint an attorney? But then if they say, if you're representing yourself, you have a fool for a client. Why do you have a fool for a client if you're representing the party who is the defendant?
And go a step further, what does represent mean? One of its definitions is bring before the public. So the judge wants to know if you're going to bring yourself before the public, or are we going to have the attorney bring you before the public? Heads I win, tails you lose.
But why do you have a fool for a client? Because the party who is introduced as the defendant is a debtor. And a debtor can't pay off the claim. So you have a fool trying to solve a problem, which by the definition, he's a debtor. You cannot solve the problem. So why are you wasting your time? Now, if you represent the defendant and you have a fool for a client, if they appoint an attorney who is his client, another fool. Because do you think just because they appoint someone else that the defendant still has a remedy since he's a debtor? Absolutely not. So anybody that goes into that contract offer that tries to resolve the contract by claiming I'm here for the defendant is going to lose. So the first thing you need to do is introduce a new party into this contract so that the new party has a remedy. That's exactly what Brandon said. The defendant's name is so-and-so, but I am the authorized representative of a creditor who's got a security interest in this defendant. And I'm here to protect the secured party creditor's interest in this defendant from this other claim. So I'm going to deal with the other claimant because I'm representing a creditor which can help this other creditor get his payment and leave this debtor alone.
Understand, as a claimant, you have standing in that court.
If you have a claim, what would be your claim? You're the secured party. What does that mean? That means I understand that I have commercial energy in me to solve a problem. I'm coming to my brother, the defendant debtor's rescue, because he is a sinner who cannot pay the price of his sin. So I'm coming in as his Messiah to pay off his debt of sin in his place, and I will redeem him in the eyes of the other creditor so that they will let my brother, the debtor, alone. That's the spiritual metaphor. And you got to do the same thing in the court. You got to recognize that, oh, over here I'm a creditor in the real world. Oh, over here they see me as the mirror in the debtor world as a debtor. They keep bringing in the debtors saying, give us a remedy, knowing that there is no remedy, so they're going to slap them down. You got to be competent enough to know that over here you're the creditor, but you're not named in the suit. You've got to introduce yourself, and through contract you've got to be brought in. Now there's a problem. You come in as a creditor, you got to stay in that private world of the republic. If you as a creditor set foot in their world of the democracy, you have just lowered yourself into being a debtor. You're incompetent. You have no remedy. So you've got to establish your jurisdiction.
So when I go into court, if I'm going to not step into their world, kind of give me an example what's not stepping in their world, and how am I doing that again? You said that. I don't understand.
It's contract law. If you receive a benefit from the public, then you've given up the private and you're stepping into the contract jurisdiction of the public to receive a benefit.
So you're saying in that context, you're talking about if I were to accept an attorney or technical counsel or standby counsel or some kind of benefit like that, or enter into the bar
It
without
changes.
somebody-
Remember, Brandon said that the jurisdiction of the contract can change, just like any other terms of the contract.
Hold on.
And
So-
you've
so I
actually,
might-
at that point, have you not also confessed your incompetence
So let me ask.
if you have an attorney? Are you keep turning it off?
No, I think I got batteries are out now.
Is it yellow?
Yeah, it was yellow just a second ago.
Okay, so while he's getting his batteries up, that's why we have basically told you to be competent, since it's all contract law. The first thing you have to understand is the parties. You got to understand who you are. There are 3 character roles you can play. Sometimes it's referred to as me, myself, and I. And each one of those character roles is a different character role in the public. Me is the debtor. It's me wants this. Me wants you to do this. Me wants a benefit. Me doesn't want to do anything important. Me is the straw man debtor who is in the public. And it's always the ego trip with him, it's about me. Myself is the other part of that trust, which is on the private side, which is the creditor. Remember, Mom keeps inducing the kids all day long to do their work. Freddie, take out the garbage. Oh, Mom, me doesn't want to take out the garbage. Me's playing a game. Why don't you have my brother take out the garbage? So Mom goes, brother, take out the garbage. It's not me's turn to take it out. I did it yesterday. Aren't the kids acting like debtors? No responsibility. Until Mom finally gets so frustrated, what does she say? I'll do it myself. I will be the creditor. So myself is the party that you play when you act like the creditor. Me has a name, all caps. Myself has a name, upper and lower case. They're part of that trust. The one, the myself on the private side, the me on the public side. Me is a debtor, myself is a creditor. But then there's I. I has no name. I have pre-existed from before I was conceived in my mother's womb, the Scripture says. God knew you before you were even conceived. He may have had a name for you. I don't know if he whispered that in Mom and Dad's ear when you were born. But remember, in Scripture in the Old Testament, when Moses tried to pin God into a contract, Moses said, who shall I say sent me? And God said, tell him, I am that I am has sent you. He gave no name. If you give a name, you are going to be a debtor or obligated. The I is the spirit. The myself is the soul. The me is the body. The body and the soul different because the soul infuses life into the body. When the soul dies, the body is lifeless, but the spirit goes on. The body, the me, the debtor, returns to the dust of the ground and decays. The soul may come back at some time when the Creator infuses that life at some other time into some form of vessel. But the I, the spirit, is that which survives. And so you have all 3 of these roles of character to play.
It's interesting, a spiritual context of that scenario there that just occurred to me is that, just like he spoke in the Bible that, who shall I say sent me? And it was I am that I am. When is when you use a name, isn't it the only way you can get something assigned to you, an interest, a right, a title, an obligation, is when I give up a name. However, if I'm only ever appearing to give, I need not disclose an identity. The ultimate creditor is one who just is in giving and not in getting. I am forgiving, not forgetting. So when I am forgiving, I need no name. I come with gifts.
This
So
will
when
kind
I'm
of be
forgetting, I need a name to associate the gift with. I want a gift from you. And so the me must come out, the name, to get something.
In other words, the currency can transfer without any name.
Right. But the
However,
benefit,
the title-
benefit has to be associated to a
Correct.
name. So that was it's something that just occurred to me now, and it makes a lot of sense for me that the I being the ultimate creditor, because the I never has an intention of getting. The I is always in the intention of giving. And so in the book of Moses, the concept of God being the ultimate creditor, not looking for any benefits from anyone, why would he give a title?
Actually, the UCC talks about it on an instrument because they call him the principal debtor, and then after that is the surety. So me could be your debtor, your principal debtor.
The three
Myself
names,
is your surety, and
Me-
I is the creditor.
me is the principal, myself is the surety, and I is the underwriter. Those are the three commercial positions with regard to the three characters. And there's also three signatures, each one different depending upon which one of those characters you have also.
Hold on, what do you mean three signatures?
Do we
Explain
have?
it.
Do you have those diagrams? Are we going to go over those
We
diagrams?
could, yeah. That
'Cause
would be
I know
helpful.
we've broken down.
We're kind of like in an introduction right now, giving you like a
No, I
pretty
want to.
high-level
I want to get all
overview.
of this out of the way at the beginning, so that when we move into everything else, it's the foundation is there
Okay.
where of what we have.
Well, after lunch, why don't we put on that dual trust, and we'll just quickly go through those and show everybody in the diagram.
Come on, Jack. We don't do anything
Quickly.
quickly.
Could you just repeat the three again with the underwriter as one? That was so
Me?
quick, and it seemed really important.
Me is called a principal, P-A-L. That sounds very, very important.
And the
Being a
UCC
principal
speaks
means
of that as the principal debtor.
You're a debtor. That's what you think you want to be. It's the Playboy theory. He that dies with the most toys wins, because you're the title owner. You're a debtor when you're an owner. And
We
the
got myself
underwriter is I. The surety is myself.
Underwriter's like the creditor. Underwriter pledges commercial energy for the solution or resolution, or balancing or discharge or set off.
So that was for the commercial side?
It's a commercial representation of who I, myself, and me are.
And you guys get that these are mechanisms, that these are not absolutes, like you need to memorize this and know this. These are mechanisms for you to understand commerce and contract, okay? It's not that you have to, the me is the principal. The mechanism is there for you to understand there's roles. What role are you there as? See,
Because
the mechanism of I, we've given you several mappings of the me, myself, and I concepts. And they're not there to give you, like, you need to memorize these definitions of these. These are the mechanisms to help you make the distinction of the different roles. So there is the underwriter. We could call the underwriter the creditor. There's the
Surety.
which is the I. Then we have the surety, which is the myself. Okay, and what's another capacity?
He's energized by the ultimate creditor, given that creditor energy to perform.
And we could also, could we not also call him the authorized representative?
Not quite. He's the trustee of the trust. The trustee
Okay,
has the
so the
legal
trustee.
capacity.
Trustee.
The authorized representative, he is the fiction, the title of nobility that represents that trustee. He represents the myself when he's in the public world.
Ah.
Okay, so he's the ambassador to their world of the democracy and the public, saying, I'm here representing that creditor that's going to take care of this. He couldn't be here today because if he set foot in your kingdom, you'd make him a debtor and he'd lose his energy. But since I'm his ambassador, I'm bringing word from my creditor, my banker, that he's going to take care of this. And I'm just the agent here to convey to you what he's doing. Okay? That's what the authorized representative. Who authorized him? The banker, the myself guy. Who is he representing? The banker, myself. Well, why are you down here instead of him? Well, look, if our president set foot in the Soviet Union to negotiate some treaty, he would be given up rights because he's in a foreign land. But if he sent an ambassador over there as an agent, the agent has no capacity to give away any authority for the party he's representing other than the authorization that he's here for. So once they hammer out the treaty at the agent level, then the two leaders get together and sign the treaty without having to back and forth negotiate and lose any rights or sovereignty. So your authorized representative is the guy that's going to be appearing in their system to negotiate a settlement with them in public. And once they negotiate the settlement, then the myself guy puts his signatures on the contract to pay everything off.
Because like you were talking here a minute ago, Brandon, there are times when you may take on the capacity of the debtor, right?
Oh, yeah.
You know, this was where I was talking to some of you about a gal named Susie I had as a client, and we got her out of jail, and then pretty soon she's dealing with the IRS. But prior to getting out of jail, she was told that she needs to, when we put in the paperwork, the IRS wanted to have an interview with her. And she said, what should I do? I said, act like a debtor. She says, what? I says, your job at that hearing is going to be merely to answer all the IRS's questions to the best of your ability. But that's not a creditor. I said, you're not there as a creditor. To get you out of jail in the particular instance you're in, I need you to be a debtor. Huh? I said, yes, go low to get high. This is something Jack used to teach. I know it gets kind of weird, but this is where Brandon just told you. You're going to play different mechanisms for getting what you need to get done. In this case, this young lady needed to be a debtor. The IRS wanted her merely to answer a bunch of questions that they knew all the answers to already.
Right, because the role she needed to serve in that particular instance was one where the principal debtor had duties and obligations. The principal debtor there had been property pledged for the principal debtor being the body. And the body was being held in a bank, in a jail, right? So in order to free up the principal debtor must appear. Okay? Because the principal debtor is the one who has pledged the property. The principal debtor is the one who's obligated. So until the principal debtor's obligations are discharged, we cannot form any new contracts. So she merely appeared as the debtor, the principal debtor, in order to resolve that which the principal debtor had failed to resolve up until that point. Now, in reality,
what she was is she was in a contempt. She had a duty and an obligation, and the reason she was in prison was contempt. She had to purge the contempt. You cannot bring out an outsider in to purge that contempt because the contempt is the duty of the party that's in there.
Right. So how can an outsider purge the contempt? It was the principal debtor that was in contempt. You can't come in and say, well, I'm the authorized representative of that person who is in breach of contract and who's in contempt. Well, that's not resolving the issue.
Don't get too wrapped up in it. It kind of gets a little complicated in one sense. So she had this hearing with the IRS. Then the IRS put out a 3-page memo that said she didn't cooperate, she didn't do this, she didn't do that. We put in a counter response to that, signed it, and did a few things. And then there was a public hearing. And she came in and she introduced, I'm here today as the authorized representative, interestingly. And the judge just ignored her. And then the judge asked the IRS, did you receive a copy of this letter that she'd sent to the bank? Yes. Well, I see that she's purged her contempt. But you see, just like the ambassador, we did it all behind the scenes, and they came into the public, like Jack is talking about, into that country called the courtroom. It was already negotiated and done. So we came in. I said, just go along with the program. And the judge says, Mrs. So-and-so, Susie, will you attend a deposition with the IRS in the next 10 days? She says, yes. And that's what she did 10 days later. And it was everything was just fine at that point.
Okay, this is the second thing you have to know about what we're talking about in terms of contracts with the parties and the jurisdiction. In their system, since there is no money, there can be nothing in terms of trials in the public. So the trial is privately between the parties. When you go into, quote, court, unquote, you are on appeal. Your first court trial is your first appeal.
One sec, Jack. To help get that, there's a quote that says, in common parlance, going to court is synonymous with going to trial. What Jack is telling you, for example, I use an oversimplified example. The IRS sends you a few letters and you ignore them, and pretty soon your bank account is leaned and money's taken out. But you never went to a court, as you understand it, with a judge in a black robe, etc. That's court.
It's the administrative procedure between you and the other party that represents government.
See,
your trial is always administrative.
The IRS sets up a court, just as you do in your private process. You set up a court. And because you're doing it on the private side, it's a higher court.
Hold on.
Here's how the IRS court works. One party sends you a letter, and they give you a what? What's on the letter? A response address. Isn't it interesting that so many of these documents come from one address, and then they want you to respond to another address? Has anybody ever noticed that on IRS correspondence?
What's that mean, Brandon?
The witness to your response. Somebody's going to certify whether or not you responded in the 30 days.
So are you
when
telling...
you haven't, you've consented to what they sent you.
Are you telling me then I need to send something to the response address and something to the address that sent it to me? And I got to show something. Well, that's what I'm just clarifying. I'm kind of confused and I'm a little lost.
And when you're doing a process through a notary, you're creating a court. See, in reality, the court is the relationship between the two parties. The court is the witness of what's going on between the parties. The court is merely administratively going to determine what happened between the parties. What did they agree to? Because what happens is a plaintiff starts a suit. What does the plaintiff have to do before he can file anything into the court? Show proof that he already sent it to the other party they call defendant.
That was your trial. A court is the appeal. Now, what's the difference in procedure between having a trial and an appeal? When you're in a trial, you could submit new evidence. When you're in an appeal, you cannot submit new evidence. And so what we're telling you is in a traffic situation, where's your trial?
On the street.
On the street, you and the officer. If you did not raise a factual issue, by the time you go to the traffic court, you're on appeal. You cannot raise a new issue of fact in the traffic court.
Is that why it might be important that within 3 days of accepting that ticket and going along with the normal way?
Privately write back and forth before you make your appearance.
Well, should I write to the police officer or the court or both?
The police officer is the charging officer.
Yes, but he represents the plaintiff in the case.
And the prosecutor is the one technically that's bringing the case or the argument for the fiction, the state, the city, whatever it is that wrote the ticket. So certainly the law enforcement officer is the third-party witness for the plaintiff, and the plaintiff is represented by a prosecutor. So the cop is actually a third-party witness. He's the one that is testifying into the court. Remember, we said under Admiralty Maritime, we don't want any first-party discussions. We don't want the state to talk to us. We want some third party who has gotten the evidence and he's relaying that on behalf of someone else.
Absolutely. And remember, we were also talking about in rules of evidence the exception to the hearsay rule. Exception to the hearsay rule is one that an individual whose job it is to keep such records, and those records being submitted by this third party who is impartial to the proceedings, would qualify as an exception to the hearsay rule. So the police officer keeps a record. That citation is his record. And so that third-party record, the original citation, makes it into judge's chambers.
Okay, and understand this. At the scene, isn't the law enforcement officer having a discussion with you with regard to the incident? So aren't you creating an agreement between the parties by what you say and what he says? So by time he's done, that traffic citation is a security agreement. When he takes it back and he gives it to the boss and they file it in the record systems, now the security agreement has become a title, a claim, or a lien upon the privileges to do business under the driver's license, which can result in removal of the privileges of that license if their claim proceeds forward against yours. But you go into the traffic court, you have raised no issue in regard to this security agreement. So they have a claim in court, and the judge ignores you because you have failed to state a claim because you have no record of any of your issues in this security agreement which is filed.
So I could create a record if I'm timely.
Administratively, within the 3 days.
Within 3 days in A for B. But if I wasn't within 3 days, isn't there like that mechanism called nunc pro tunc,
You
now
could get
for
them
then?
to agree that even though you're late, they will still accept it, and if they don't reject that, you still now have part as the security agreement, which now, if you register in a private capacity, becomes your counterclaim. And now, since all the facts are there, you can go into appeals and have the appellate court rule.
Hold on, if I
Or
register.
keep it on the private side.
Yes?
Because I recently, being a person...
Yeah, slow this down.
Being-
You're going way too fast, guys. Slow down.
Being an individual that participates in commerce in the sense that I have a vehicle that is registered commercially.
What do you mean?
With the
You got a
state of
state plate on
California.
it?
There's a state plate on it.
Okay.
However, I merely travel in it. Now, it's not to say I don't
Do you have a
it.
license?
I do not have a license.
So how are you doing this?
Keys, ignition, gas, steering wheel.
All right, okay,
So
okay.
that's the mechanism behind it. Now, rather than argue, I'm traveling with the officer. Every time I get pulled over, I'm very cordial because I have nothing but love and appreciation for these gentlemen out there. I mean, they
Now, how many
really-
times have you been pulled over without a license, so I can get an idea here that this cordiality is extending to?
Like at least 4 or 5 times. at
Okay, got
least,
it.
Maybe more. Only once have I been given a ticket, and it was recently. Great state troopers of Arizona, and actually it was a sheriff of Arizona.
Okay,
Sheriff
You're
of
from Arizona, right, Jack?
And this sheriff, he issued the ticket, and I didn't argue. I was just like, oh, an opportunity.
Did
to
you sign it
discharge
any
an account.
specific way or in here? Just put
No,
your...
just signed as I'm the authorized representative for the debtor, but I just signed it.
Okay, just
Because
a
I
blank
accepted
signature.
I accepted the obligation. I'm
Blank
like, I'm going to
signature.
discharge this. That's
Okay.
how I saw it. I wasn't going to refute.
So
that-
you didn't put without prejudice or all rights reserved. You just put a
No.
unqualified
In fact-
signature.
In fact, it wasn't in my private capacity that he was concerned that I was traveling this state vehicle. The state vehicle is registered to the public trust.
Because it's got a plate on it.
It's got a plate on it. So there is a Brandon A. Adams, all capital letters, who is associated with it, and I'm more than willing to discharge all Brandon A. Adams debts.
Okay.
So as the party authorized to make contract on behalf, because I'm the executive trustee of that public trust, so when I'm an executive trustee of a trust, do I have to expressly state that I am acting in the capacity of a trustee?
I thought you had to like sign your name, comma, executive trustee or something.
No, I don't have to do that at all. I
Okay.
can merely, just like an attorney in fact, I could put as attorney in fact, but I could just sign my name. I don't have to state a designation
Oh,
or
because
restrict my
because
endorsement.
the all caps name is the public trust, the upper and lower is the private trust, but neither of them are you anyway.
Exactly.
Oh, okay, I got it.
Neither one of them can sign anything. So
Okay.
in reality, I'm the only one who can sign, or actually you could sign for them too. Anyone could sign for those two trusts. I chose to.
All right.
So I
go on.
signed for the trust. Now, this is something we're going to go into detail this weekend and how our current administrative process for settling things. What I did was I did a money order and A for V on the ticket.
Let me interject. This for you is on the asset side, the private side of banking accounting. This money order was not some through the post office. It's not through a public open bank account.
Are you going to give us a
So,
copy of that money order?
Hang on. How many people in here
I will.
don't understand the
know.
difference between the private money and the public money? Okay, so there's several. We will go over that sometime, but you got to have to learn that the public money will not solve this problem
It'll discharge
because
it.
the public money is still a liability. You cannot pay a liability with a
Hold on, Jack.
liability. That's called novation, not discharge.
Hold on.
If
I pay the ticket, I don't have a problem anymore.
On
What
the
do you mean it
public
doesn't?
side, they would be thrilled with you and it'll go away.
But here's what happened.
then I do
Here's
resolve
what
it,
happened
right?
as a creditor. Remember, as a creditor, we want to take responsibility, right? We want to set off the debt. See, what happens, Jack just made mention of a novation. So it went from being a debt or obligation for Brandon A. Adams. What happens when you put Federal Reserve notes onto that account? Whose debt is it now?
United States.
Everybody in the United States.
So you just created a debt for the entire United States.
You passed your
You
debt on
passed
to the
it on
public.
to someone else.
So I got rid of the problem for me personally, but I created a problem for the whole nation.
What's
Exactly.
happening right now in our economy? Doesn't our president tell us that the public economy is stagnant? It's at a stalled position, and he tells you the private economy has to come back first so that we can then energize the public economy to get it going. The fact that you people are all using Federal Reserve notes and checks out of your bank accounts is creating our problem today.
Yeah, but I
because
don't
it
have
has
any-
loaded the public with debt, and there's no remedy. You've got to learn to be private.
Yeah,
And
but I can't go buy a car and a home yet with these.
No. Hold on. You can still use the Federal Reserve notes and checks. Learn how to set off the debt you created with them.
Yep.
Because what are you going to get in exchange?
Title?
Full title.
A document
Full
of title.
title?
Full title.
Hold on.
Why aren't you taking that document of title, accepting that for value, and depositing it with the Treasury?
Hold on. What title am I getting? Help me. Slow down a little. I'm not
If I
getting
go to
this.
the grocery store and I buy a can of beans, I get a document of title.
Yes.
We call it a receipt.
I understand that part. That's
Now,
easy.
what is that? What is that evidence of? That a debt was just created because the novation happened where Federal Reserve notes. I took the title, but the United States took the debt.
Are you suggesting I
And
take the
federal-
receipt and do something with it?
Give it to the United States. Give them title to your can of beans.
Are you suggesting I take all my receipts and like A for V 'em and send them in or something?
All of them. I would bundle them together with a bond or something. Is how I would do it.
And you know what you're getting in return?
What?
Currency, because you're selling title.
Hold on. You telling me if I bundle all my receipts, all of my other things, I can send
Cancel
that in and
checks.
I'm apt to get it?
1099 OID.
What's OID
process.
mean?
Not there yet.
Okay,
Original
we'll get it
issue
later.
discount.
Now, yeah, I
Just
wouldn't
weighing
even
on you.
I wouldn't even touch on that because until you understand all the aspects of operating as a creditor banker, meaning you're setting off all the debt that you create. Every dollar of debt that you create out in the public, you're setting off. So that at the end of the year, there's a balance. You didn't create a dollar in debt. Okay, so it's not like I want you to go try to A for B a car. It ain't, good luck. You know, I don't see it happening. Or using your private money order or bond and promissory note to buy a car, it ain't going to happen. But if you create the debt to get the car, set the debt off. Because there's going to be what? A loan created. Now
So
there's this obligation that can be set off.
I could do this with credit cards, mortgages, everything is what you're talking about.
Absolutely. Now let me
Okay.
get back to the obligation, which was the ticket. And so instead of going through the clerk, or like a lot of times people are sending A for Bs into the CFOs of a bank, right?
Well, let's deal with
anyone
just
know
your,
what usually happens?
Let's just deal with your tickets to keep
Okay.
it simple for me.
What I'm saying is, don't go through people who don't cast pearls before swine. They can't do anything with the A for V. So who do I send it to? The people who can do something with my A for B.
IRS.
I send it to IRS in Ogden, the people who do set off.
Is that different than the mail stop?
4440. Yeah, mail stop 4440.
What about, is that Tech Support Division on Pennsylvania?
You could send it there as well.
Either one, huh?
Yeah. Right.
Okay, so it's just one of the two, right?
Find where, I mean, there's probably, I imagine there's more than 2 or 3 set-off offices for the IRS in the United States.
There was like 3 in the Doug Riddle stuff, like any
There
one of
was-
those 3
there
work?
was Covington, Kentucky.
Kentucky,
There's
Ogden, and Washington.
and Washington, D.C.
Could I do any one of those 3 or just the 2 of the 3, you think?
You could do any of them.
Okay.
I maybe do some due diligence. Call up the IRS.
But you're just sending it to IRS
Literally
text.
ask them, where do I send set-offs? Who do I talk to about where to send a set-off to?
Have
Who
you ever
can
asked
handle
them
a
that?
set-off? No, I
A
haven't.
set-off is different than a payment. A payment is on the public side. A set-off is on the private side.
And we actually, what we did was years ago when I first started doing this, me and a friend of mine, we read through the Internal Revenue Manual, and we saw that in the Internal Revenue Manual it said that you could pay your IRS debt with a bond. We're like, a bond? So we started doing research. Well, how do you create a bond? So we created a bond. We read in the Internal Revenue Manual when they receive that bond, their job is to send it straight to CID. Not only that, they have to seal it up. They have to do all kinds of things to make sure that this instrument arrives at CID untampered with. Okay? CID, which is who you're sending it through, if you go through Mail Stop 4440, you're going through CID. That's the Criminal Investigation Division of IRS, for those of you who don't know who CID is.
That sounds real scary when you're doing your commerce, doesn't it?
But every time we've been dealing directly with a revenue agent and we've sent a bond into that revenue agent whose job it was to then forward it to CID, not only did we get the set-off, we got the set-off like that. Why? They know, right, who to send it to. And the person they send it to handles it because it's coming from a revenue agent. It's not just coming through the mail. It's coming directly from a revenue agent, directly to the CID agent, whose job it is to inspect this instrument and set off the debt. The funny thing is, the first time we did it, he got back a bunch of statements for all the years we didn't discharge from CID, literally less than a week later. And it wasn't even statements. They were like computer printouts. Like not like typical anything from IRS. It didn't even say IRS on it. But it was a printout from Covington, Kentucky. Basically looked kind of like a statement matrix, where it's like, the tax year and the amounts, and like down in the lower right-hand corner is an amount due. But they didn't say pay it. They didn't have a coupon, nothing. Just a bunch of pieces of paper to say, oh, you're a creditor, let's see. We sat on them for about 6 months, scratching our heads like, what do we do with these? Finally, we decided, let's make some more bonds.
Here is the issue. Can you only be a part-time creditor, or do you have to pay every debt obligation you've got to be a creditor? So when the first bond went in for the first year, you were saying, I want to be a creditor. Here, I'm going to set off the public liability for the tax liability for this year.
Yeah, and they said, all right, handle these 7 years.
Well, let's see if you'll take care of everything then. What happens if you're selective and only pay part of your debts? Are you a creditor or are you a debtor? You're going to be a debtor, because if you owe anything for any part, you're a debtor. So they're going, well, we're going to test and see if you want us to receive your bond for this year, 2008, let's see what you're going to do for the previous 6 years. If you choose not to be a creditor once they've raised that issue, then they're going to say, well, we're going to disqualify your bond on 2008 because you can't just be a creditor on part of your debt. So in reality, didn't we say when we started this, you got to learn how to contract. You got to know who you are. You got to know the jurisdiction. But then when you start doing your contracts, there's a lot of these maxims that Brandon hasn't even gone through before. And part of the maxims are you can't just pick and choose when you want to be a creditor. You got to be a creditor to that party in everything you do, or you're still a debtor.
You can't be double-minded?
Double-minded. And if you think you have the capacity to be a creditor and use a bond on your asset account for 1 year, when you openly choose to remain a debtor for 6 other years, when we brought that to your attention, then we're going to step in and disqualify your ability to contract as a creditor in this year because you want to pick and choose. Sometime you're a debtor, sometime you're a creditor, you're double-minded. Scripture says a double-minded man is dangerous. He's incompetent. Incompetent means he's a debtor. A debtor cannot access his asset account, so they will say, this is foolishness. This is frivolous. You can't file a bond for 2008, but it comes as a result of your inaction to demonstrate that across the board you understand you're competent and you know what you're doing. So once again, when the government seems to reject what it is you did, first look in the mirror and say, anytime you get a letter saying, hey, I don't like that, the first thing you do is, did I do it right or wrong? Or are they trying to knock me off my rock so I don't get my remedy? It's going to be one of those two things. But the first thing you have to do is sit back. Bring your friends in. Bring in your buddies that also are doing this. And go, are they telling me I've got a problem and do I have to correct it? So that I can just lower my ego and lower all of this testosterone and forgive me, this is what I need to do, and then go back and correct it, or conditionally accept it because they're just testing you to see if they can knock you off the rock and make you act like a debtor again. It's going to be one of those two, and it's going to be difficult for you to analyze, was I right or do I need to correct or do I need to stand my ground? There was a question?
And hold on, I wanted to add to that. Another maxim, which directly relates to what we're talking about right now, is that in the question of debts and debtors, that the surety determines the method of payment or discharge.
Say that again.
In the question of debts and debtors, the surety determines the method of payment. So you've heard in certain cases where people go, well, we don't accept that form of payment. Really, are you the surety? Because only the surety can determine what method of payment will be made on behalf of the debtor.
Who's the surety in the contract? It's myself, which is your creditor side, because you're the one that's coming in. Can the other party say, well, we only take Federal Reserve notes? They cannot dictate or determine the method of payment.
Only
See, when you get a statement from anybody, they'll say $55. Can they say, well, we want $55 in Federal Reserve notes?
Can they say we want $55 in gold? Can they say we want $55 in silver? Can they say we want you to send us your wedding ring? No. They cannot determine the method or form of payment. Only the surety can.
Because nothing has been known or declared to be a money. So it's your choice. As long as the amount of dollars in value are there, it's your choice. But when you come back and try to use your asset funds, and you've done it right, they're going to try to knock you off your rock. They're going to say things like, oh, that isn't currency, or that isn't U.S. dollars, or we'll only take checks, bank checks, postal money orders, or whatever. excuse me, under HJR 192,
Don't make an assertion, ask a question.
that's absolutely correct. I'm not going to tell them, but I conditionally accept it on proof
There you
of
go.
claim that they can show me under HJR 192 that they can ask for any particular type of money as a currency to be used to set off this account.
Or ask them, are you the surety for the debtor?
You know, we've had,
Isn't it not true that only the surety may determine the method of payment or discharge of a debt on behalf of the debtor?
So they're trying to knock you off the rock by giving you something which is going to be out of context or unauthorized to ask.
we had a recent student that was in court,
I still haven't
Went
finished
down.
my ticket story.
We're working on it.
went down to pay the fine and asked the clerk, how do you want it? And she said, any negotiable instrument.
The clerk said that?
Yes.
I love it. I love that clerk. What court was this?
Huh?
What court was this?
I'm not sure. I think it was one of the California guys. You know, that the clerk of the court says any negotiable instrument. And I've had a judge say that too in a case.
We had a guy who was registered on a UCC and brought the UCC notice to the bank. He's trying to get rid of a foreclosure. And he came to the bank. He had his documents there. And he said to the bankers, I'm here to settle this matter. The bankers looked at him and said, we will take any form of payment you want. Just don't send us that crap like everybody else.
I understand that you need to be consistent in one relationship as creditor, but do you have to, in all cases, be
Only
creditor?
what they connect in the agreement and the contract.
You don't have to be a creditor ever. You choose to be a creditor.
Well, I mean, do you have to be a creditor in all cases if
I
you
think
are
he's
ever
talking
not
about
a creditor?
He's talking about layman.
Yeah.
He's out here buying groceries with FRNs. He's out buying gas with it. Over here, he's trying to set off his account with the IRS. He's asking, can he?
Right. Again, it's choice. And if you truly want to be a creditor and you truly want to be a benefit, you know, you want to benefit the world around you as opposed to taking the benefits from the world around you, then you'll probably seek a way to achieve being a creditor in all aspects of your life.
Everything
I'm
you're
not
doing.
saying go home and A for B all your bills. Okay?
No.
But the IRS won't say, oh,
No.
he's not a creditor
Hang
just
on.
because something else happened.
I think
last
what you're
week.
saying is if
Remember,
if you
you're
sent
not the
that
account holder.
if you sent that bond to the IRS for 2008, they're not interested in whether you purchased your groceries with Federal Reserve notes yesterday. But if in a response to that communication coming out of IRS is another letter, even if it's from a different place in IRS, all of the records in IRS go into a master file, and so everybody can see what's going on in there. And they're going to see he picks and chooses to be a creditor here. There's another document currently pending in his file because we're negotiating a security agreement. And he chooses not to act like a creditor there. He's double-minded. But that's only because they're brought together in a negotiation in a master file between those parties. You might have a car loan over here which is not paid, but that car loan, unless it's brought into the discussion with IRS in the settlement of this, that car loan, you may be a debtor capacity, but it's only in the security agreement between these parties at this time that things have to be consistent.
And keep in mind, you're not the debtor.
Well,
The debtor is a party that you're clearing up the debts for. You're the creditor always. You've chosen to pick these debts, the IRS, to settle first. Then you're going to go around settling this debtor's debts with all his other accounts.
What Jack's
separate that you're not the debtor, so you're always acting in the capacity of a creditor.
When
Okay.
you choose you want to.
What Jack's kind of telling you is, let's say that you set off your 208 and 209 with asset instrument, and then they send you a bill for $22. You know, you just got done discharging $1 million. They sent you 22.
Yeah, they're like, oh, you know, there was a little bit of interest.
And this happens a lot. They get
I've
a little
actually
bill.
seen people do this. They like get a bill for like $2 or $3. Like, oh yeah, you settled the debt, but there was interest, so there's like a couple dollars more. And people will turn around and write a check for it, and then watch how their bill went from $2 to back to being $20,000.
That's what he's talking about.
$5,000 frivoluses too.
That's
Because
the
you're
double-minded
mixing.
aspect. So yeah, don't mix it, especially when it's the same account, same tax year, same entity that you're dealing with. Just like if you're dealing with a bank on your mortgage, and you're doing a private settlement with private money, and then you decide to just pay with a check one month. Remember what determines the contract? Your conduct.
This will even
By
get,
writing that check, you've determined the form of money that's going to be used to discharge that debt. It's now you've chosen to use debt funds, you've chosen to use checks, you've chosen to use Federal Reserve notes to discharge the debt as opposed to your private money. So you've abandoned that private money. So you can go back to private money, but you got to start that process all over again because you rewrote the contract when you wrote the check.
we have a client that just received a satisfaction of lien on her mortgage.
Paid it off with asset.
Got it from B of A, satisfaction of lien. Shortly thereafter, a month or two afterwards, the mortgage company called and said, look, if you don't make a payment, we're going to start foreclosure right now. However, there is $600 and some odd in this account, and there's $1,300 in this account, so if you tell us to, we'll just go ahead and make the payment for you. She said, okay.
The accounts that held those funds were public liability accounts. She had set off the whole mortgage on the private side. If you go into a bankruptcy court and you get all the debt discharged, but you walk out and an attorney for one of the claimants said, you know, that really sucks. You guys are stealing from my client. Wouldn't you at least make a $50 payment? If you pay that attorney, then you've reinstated that debt because you just entered the contract to pay it again after it was discharged. So what happened is this woman set off that whole mortgage account. She got a satisfaction of lien back, which she then filed in the county recorder's office, and then they come back 2 months later because they're going, hey man, that was on the private side. We'd like to see if we can get them back in the public again. And so they made an offer. You don't have to pay us anything. We'll just debit it from an account you've got going.
They didn't want any money orders.
Failure to respond is consent. If she responded and said, yes, go ahead and do it, she just made a new payment, reinstituting the whole debt. But then it gets even weirder because she's involved in a divorce. And her husband found out about this, and her husband thinks she's crazy for having paid off the mortgage with an asset instrument. And so he goes, oh my God, I don't want to be saddled in the divorce with this debt, but the house is in foreclosure. So he makes a monthly payment to the bank to bring the mortgage back up. So now what has to happen is she has to send a notice to the husband. Remember, they're in divorce. In a divorce court, one of the first orders the judge puts out is that neither party can go out and engage in a commercial contract which is going to throw liability on the other party. So when she found out that the husband made some payments to the bank on a mortgage that's gone, she had to send him a notice, please cease and desist because you're in violation of the court order. And any liability you take on with respect to that mortgage is going to be your debt. It's not going to be mine. So now the husband had his debt discharged, which means he's got some assets, but now he's taking on the whole debt himself. But the wife has already got filed a priority recorded lien on the asset of the property, not as the debtor straw woman, but as the creditor that loaned the money to the straw party to pay off the debt. Now, who's in the divorce action? Is it the me party in the divorce or the myself party, or is it both? It's only the me party, because only the me party appears in the public in the marriage.
And that form of a marriage is a corporate binding of the two corporations.
Just the public side of them.
You can have your own marriage that's outside of corporate sponsorship, but that's a different kind of contract. So,
We've got a question
Yeah,
over
okay.
here.
If you will, Brandon, I'm still in Arizona.
what's that?
So if you will, I'm still in Arizona.
He wants you to finish the
Oh, you want me
story.
to finish it?
Yes,
Okay.
yes, please.
All right, so what I did was, instead of sending the settlement in through the clerk
Or the CFO
sheriff,
of the court.
yeah, or anyone else, I sent it to the people who could handle it. Now,
Who was that?
the IRS,
Okay.
set off, or CID, stop 4440. Now, I wanted a record of this because what I wanted to do was make presentment of this record. And like I said, we're going to go over this in detail. I'm going to show you the complete administrative process as we do it when we do settlements like this. Could you guys kindly turn your phones off during workshops? So I took and I made presentment of it through a notary. However, there were no notarial, no certificates of service or anything inside what I sent to IRS. What went to IRS was a typical set-off package. The A for V ticket, the money order, and
1040.
1040B. That's all that was in the envelope. However, the notary witnessed that that's what was in the envelope, so I did have a certificate of service that went with copies of everything that was in that envelope. Okay?
But you didn't send the certificate of service.
I did not send a copy.
You kept
of
it
the
in your
certificate of
records.
service. I kept it in my records. Okay.
Got it.
I then took that record, the notary's record, of what was sent, and the certificate of service itself, and proof of mailing, and I sent it in with a notice of tender for set-off to the clerk, saying,
The clerk of the court?
the clerk of the court,
Not on the public side
on
or
the
the CFO?
private side.
So that was who?
It was the
head clerk.
The head clerk of the court, yeah. Whoever the head clerk of the court in their private capacity. Whenever I say I sent it in private capacity, let me let you in on some of the practices that I use to make the distinction that this is a private contract. The envelope is stamped private. It is stamped confidential. It names personally who I'm privately contracting with in their personal capacity.
Just by putting the clerk's
Their
name without any
name.
title, right?
Yeah, typically I don't put a title. Sometimes I will, sometimes I won't, but their name is paramount. So it's so-and-so, care of whatever court, address. That's another distinction that I'm
$21
making,
and stamp.
is using the name care of the court, meaning I'm not sending this to the court in its commercial capacity. I'm sending this to the clerk in care of this court because this clerk does business in this court. Okay? Yeah, I do use $21 of postage, and I declare the value and I do it registered mail. And so
Why $21 worth of stamps? What's the big deal?
it gets into Universal Postal Union, common law. There's a couple reasons we do
Just
that.
do it, right?
Yeah. We can go into the explanation of that, but let me finish the story. Along with the record was a notice of tender for set-off, which is basically saying, hey, you're getting paid, or you got paid through IRS.
IRS is the agent for the bank, your private account, that has the authority, as you've given them that authority, to debit your asset account through IRS, which is the auditing company for the bank, the Federal Reserve, and it goes through the U.S. Treasury as a pass-through account to get them paid.
Okay.
So what you did is, instead of paying them by giving the beneficiary a check to go to the bank, you went to your bank and told them to pay the beneficiary, so you're giving the beneficiary notice he's getting paid from your bank.
Okay. Along with that notice of tender for set-off, I included a request regarding a statement of account, which showed the statement of account on that particular account, case number, citation number, being 0. Now, in the request, I stated that this is a verified statement by the debtor. Okay? So, because remember, as the creditor, this wasn't my debt. This was the public trust debt. So the statement of account is on behalf of the public trust because I don't owe anything. Right? in my private capacity, nor does the private trust owe anything. So I'm not going to use the private trust name either because the private trust is in the clear. The public trust has a liability. So the statement of account is sent on behalf of the public trust. Okay? I execute it as the executive trustee for that public trust, and then basically request that correction be made. That if correction is not made, that the zero balance is accepted. That this is the statement of account for this account. And then I include below that the record of what went to IRS. And then, of course, a certificate of service. That all goes into the clerk.
Isn't his statement from the debtor an offer for a security agreement? Isn't that what he's doing? Trying to get them to agree that this is the current status. And if they come back and agree, we've got a security agreement. And if that gets registered, i.e. in the files of the clerk, that's a claim. And this claim sets off their claim of trying to charge the straw man on the ticket.
Once again, he talks about security, any evidence of debt or ownership. He shows a zero count on there. That's a security, evidence of debt, no debt.
Their failure to respond is agreement with the security offer. You see what they're doing? Because they're trying to collect the currency, the fine, and what they owe back if the currency goes in is the receipt, which is the title. But since they're not going to do that readily, what Brandon is doing is he's sending them the offer on the security agreement, which is the verified statement of the account coming from the debtor. And their failure to respond to that is a consent that that security agreement is valid with us. We've accepted it.
Oh, and that process was sent through a notary. So that was notary presentment, and
Third-party
all
witness.
responses were to be directed through the notary. So now I've got a witness that there's no response from the clerk. So what do I have? Agreement that the statement on that account is zero.
So go on, tell us the rest of the story.
That's it.
Did you do a second and third step? Are you going to do a second and third step?
By getting a non-response to that, I've got their agreement.
Okay, to make it a title, because we don't know if she's ledgered anything that's agreed there, if there was a UCC1 filing from the creditor, then this failure of response, you could get the notary to do a certificate of non-response or certificate of protest. That becomes the title when it's filed, and you can file notice of that on a UCC3 because the Secretary of State's registry is for the private filings, the county registry is for the public filings.
UCC3 if you're appending an existing UCC. Otherwise, you just put it on a UCC1.
Correct.
And list the account as collateral. The public trust is the debtor. Private trust is the creditor. And so the account, because the private trust issued
The
credit,
currency.
issued the currency. So it has a security interest equal to the value of the instrument that was tendered.
The currency.
So the collateral is the case or account number. Who had interest in that case or account number?
Police officer, the court.
Police officer, the court, who else?
Defendant.
The defendant.
And the secured party or the creditor who's going to pay the defendant's
Well,
bill.
now he does, and now he's registered that interest. And I could send that along with my process. Typically, when I do court processes, because as a creditor, I'm always looking to set it off first. So once I've sent in the set off, then I register my interest in the case or account number. And I send that along with my private record to the judge, showing him I've also got the paramount security interest in this case. So I'm basically ordering you to do this. It's my case. I own it.
But you're not going to do a second and a third step to complete the administrative process with the court?
It's complete. She agreed. She agreed that it's zero. Now, if they attempt to do something outside of that agreement, meaning they conduct themselves in a way that suggests that the account is not zeroed, well, then I would continue a process because now
Did you verify
I
it was closed or anything, or did you do something that gives you the comfort feeling not to do it?
There's
You're like on that.
that particular case is just nothing on it. It's
But-
just the funny thing is, for over, what did it just appear last week? This actually happened in early May.
All right.
And it never appeared. In fact, at first, the clerk responded to me saying, there's no record of this case.
All right.
Okay? Then, all of a sudden, the case appeared like a week ago. And so I did another process. Well, not another process. I just sent my process to the clerk again. Because I'm like, well, now it's there. So I sent it into the clerk again.
The same.
Same clerk, same process.
Are you going to then do a second or third step now on it, or are you just going to
No.
do the one again?
No, I'm just making, because her first response to me was, we have nothing with your name on it. We have nothing with these numbers on it.
Was that by phone call or letter?
No, it was my commercial process. When I had sent in my first commercial process, she sent me a letter back.
That's what I'm talking
Yeah,
about.
and the letter said, we have no record with anything with your name on it. We have no record of anything with these numbers on it. So they were basically saying, there is no case. And then she actually had, if you'd like to initiate one, here's how you go about it.
So you just let it sit, and all of a sudden a week ago you had something. So we had what, May, June,
So
July?
I did. There's a level of due diligence you probably should do on everything, especially on something like that where it just wasn't there, and it appears 2-3 months later.
Let me ask you a question. Did you ever respond to her notice that there wasn't anything there and accept that?
After I searched it online, and after I found that it did appear, actually my brother found that it appeared, then I sent in the response.
I understand, but I mean, if she said on the phone, was it on the phone or a letter?
No. When she sent me the letter, we were in agreement that it was set off.
Okay, but did you accept that? Because that letter was
Hell yeah, I accept that. I accepted it set off.
Did you
Did you
accept it and send it
accept
back?
and return it to her?
No, it had no commercial value. It didn't have a face value. I remember I did my set off through IRS. They accepted it.
Correct.
So the way I looked at it was IRS already zapped that account before the clerk even got her hands on it. That's how I saw it.
Okay.
So I'm like, yeah, I'm in acceptance. We're in agreement. There's nothing there. But then when it did appear, I'm like, oh, well, I better give her notice of the payment that went into IRS again.
Okay, the issue's coming up in conduct that if you respond to something that isn't there, you've created a controversy. And
I respond to something that isn't
that really
there.
isn't there. And the issue is she agreed nothing was there.
Right.
But that was an offer to you. I'm suggesting that if you accept in writing and return to her that nothing isn't there, and then she comes back at this time, I would have done a conditional acceptance on proof of claim that my acceptance of your offer that it isn't there doesn't make your current...
Yeah, but it was just as simple for me to just send her the process again.
Okay.
Because in reality, now I've got two witnesses. I've got a first witness that shows you said there was nothing there. Now I've got a second non-response to the second process that, again, you say there's nothing there or that there's a zero balance. So now I've got two witnesses.
Okay.
A double witness to the same facts that it's set off.
And where do you register the debtor's interest?
The debtor's interest is registered on the citation itself or in the court case because the debtor is named in the court case. I register the secured party's interest on a UCC.
UCC 3?
Yeah. UCC 1.
UCC 1?
Yeah, UCC 3 is for amending or altering a UCC 1 in some way.
If you already have a foundational 1 on the creditor, you can add additional collateral through a 3.
Yeah,
If
but
you
I don't
have
do that
one,
because
put a
it's
3.
non-related.
Yep.
If it's not related, I just issue a new UCC 1. You can have 5 billion UCC 1s filed.
Sure.
It doesn't matter. It's in reality, because this particular UCC 1 only pertains to this particular case.
Okay.
You know what I mean? So I register it as a separate instrument. You know what I mean? Because if I just did the UCC 3, then I would also have to send them my UCC 1, which if my UCC 1, which is the one which had my birth certificate numbers and all these other things on it, I don't want to put that out there for them to even see. Because that has a lot of information about the accounts that I don't necessarily want to disclose to them. You know, especially because the other documents that may be attached with that UCC 1. Because that I would have to send them that entire record in order for that UCC 3 to make any sense. Because that UCC 3 is an amendment to a UCC 1. So you need to send the UCC 1 that goes along with that UCC 3. So whenever I'm registering an interest in something, like even when I issue an instrument, for instance, I issue a bond and promissory note or a bond or even a money order, I register my interest in it first on a UCC1. Then I assign my interest to whoever I'm issuing the note or instrument to. I've now created a new secured party, and I list as the collateral the instrument itself. Okay, so I'm saying I have an interest in, let's say it's a bond and promissory note. Okay, so I have an interest in this $5 million bond and promissory note. That's on the UCC1. Private trust is the creditor, public trust is the debtor. I then have the private trust, the creditor, assign its interest to the recipient. So if the recipient, let's say in the case of a
bond on a case.
Here, my court case, the ones with the summons and complaint, not on the ticket, but on my other court case, the instrument went to the attorney, right? But it was made to the United States Treasury and the Secretary of Treasury. So I named 3 assignees: United States Treasury, Timothy Geithner, and the attorney. All 3 were now had a registered interest in that note. And the note was listed on the UCC1 and its value, and then the note was listed as the collateral that was assigned on the UCC3. It was an assignment. So I used that UCC3 to assign the private trust interest to the recipients of the instrument and those who I wanted to have the capacity or to have an interest in that instrument. Because basically, once it's left my hands, I'm giving them the interest in the instrument to discharge the debts, to set off the debts that this was tendered for.
Since he put notice of it in the public record, it's a registered security.
So the same thing for the citation. You convey
Register
the
the money.
interest.
Yeah.
Convey the interest to.
But that interest, typically I don't do that when I'm dealing just with IRS directly. I could, but because I've already got a track record with them of them setting stuff off without having any interest assigned, because typically what I do with IRS is I'm taking the money order, right, and I'm endorsing it. That blank endorsement is an assignment of interest. It's just not registered in the public, but they're willing to do the set-off without having, and remember, my process won't be with the IRS. You know what I mean? My process is with the clerk, the court, or the bank, or whoever I'm sending notice to what I sent the IRS. I have no problem with the IRS, right? Because they accepted it. They accepted it for the set-off. So now I'm giving notice to this other party over here. Okay? Now, because in that court case, the instrument actually went to the attorney, that's why I registered the interest and assigned the interest.
So they can't steal it.
Exactly. Okay, makes sense? Are we over time? I thought
No,
saw
about
Garrett
10 till.
waving back there. Oh, we have 10 minutes? Cool. Okay. I think I finished the story, didn't I? Yes. Sweet. All right. Did we have another question? I thought we had another
We
question.
can break early. It doesn't hurt.
No, we could. Are we complete on this idea? Because we're going into the private-public trust when we get back.
We are. Are there questions before we break for lunch?
2.
We have a couple questions.
I'm wondering, in the mortgage situation, when you sign the note, at that point, are you the underwriter of that instrument?
You're talking about typical mortgage situation.
No, as a creditor, you signed a note, but were you the underwriter?
Let me answer that.
Okay.
You play different roles.
Wait, I want to be clear on, is this an instrument you're tendering
Not
to
now.
set off? Okay, this is your
You're
initial
talking about a regular
promissory note.
mortgage.
Okay.
You just go.
Regular
way
mortgage,
they
you
just
you
do it in
signed the
public.
note.
Okay.
And there's
Right.
there's
The
me,
three
myself,
capacities.
and I. So
Yeah, but there's 2 contracts you're signing.
Yeah.
The first one
note
is
and
the
the mortgage.
note in which you're actually lending the money to the bank because the bank has nothing to lend you until you give it to them. Okay? The party that is signing, any time a hand has to move, it's got to be attached to a living entity. The creditor is the private trust. The debtor is the public trust. A trust is a fiction. It doesn't move anything. Some living being has to be playing a role for any fiction to accomplish anything. So someone has to be moving a signature on a piece of paper. The underwriter, the I, is the living man with the energy. The underwriter either underwrites a surety, which is the creditor, or the underwriter signs for the debtor, which is the principal. So you have two parties, two witnesses all the time. The one moving the pen is either doing it in his capacity in the trust as a creditor, or he's moving the pen in his capacity as the debtor. So every time in your life, you're the underwriter for the surety, or you're the underwriter for the principal. On the first contract in the mortgage, you were the underwriter for the surety, because the surety is signing the note where the bank goes through the Federal Reserve, the SEC, to the DTC to get funded back by selling a security to raise currency, but the currency they're raising is the liability funds. Those liability funds by the bank are then the money that's loaned to the debtor in the transaction. The debtor is buying the house. So he's going to be the owner. He's the principal. So you got to sign a second contract with the bank after the first. The first contract, underwriter for the surety, you're signing on the right side because the right side is the creditor. In the second contract, you're signing as the underwriter for the principal, taking on the liability of having to pay back Federal Reserve notes, which is liability funds to the bank. You're signing that on the left side of the contract. So get the picture. You signed as a creditor, you signed as a debtor. Are you competent or incompetent? So you're treated as a debtor in the public process. See, they don't do anything wrong. We don't know who we are. We don't know when we're on a contract who we're signing as.
And I don't necessarily see anything wrong with that system. Like
Works perfect.
It's as far as I'm concerned, it's perfect the way that it is. In fact, if you didn't underwrite the debtor and the surety, we couldn't create money like that type of money. And I believe more in this system than a system of asset money, because asset money will be hoarded. Whereas when you recognize that the people, by their true faith and credit, are the source of all money, I think that's a pretty cool system, because it recognizes the unlimited capacity of every individual, not the capacity of individuals to hoard resources and pass them down generation to generation.
If you look at the Depression of the 30s, it was because of exactly what Brandon said. When the creditors took back the currency, they hoarded the gold, and the whole economy went to crap. Okay? You have a 180-degree change between the Depression of the 30s after the 29, as you have the problems right now in the economy after 1999, because we didn't have asset money, gold, in the economy 1999. You create money to circulate by creating debt. And so when the debt became due in 1999 and they canceled the debt, they canceled the money. And so the problem that we're having now is the opposite. We haven't taken money out of circulation because the asset money is hoarded and hard to find. The problem we got in this decade is people don't understand the nature of money, and because they don't understand the nature of money, they don't discharge or set off the public debt so that we can restart the system over again. But Brandon, I agree with his position. We're better off in the current money system if people only understood what it was and could use it competently. There was another question?
Isn't it true that the Seventh Amendment...
Put it up to your...
Yeah, isn't it true that the Seventh Amendment guarantees you a jury by trial for all contracts greater than $20 in value?
That's correct, which is where $21 comes in and what Brandon was talking about a while ago. But you got to understand the nature of what they're dealing with there. First of all, those original articles in amendment were under the Bill of Rights, which were the amendments to the Constitution. Like Brandon said, the Constitution doesn't give you your rights. The amendments to the Constitution were things there that acknowledged that the people, not respecting what the government was given the power to do, still had things that the government could not get involved with and do. But remember, those articles and amendment were when our government's public operation was under a republic. Since the Civil War, they've inverted, and the public operation of government is under a democracy. And under a democracy, you've got a different source of money, currency, and titles. And so your rights that were recognized there, not granted there, but recognized there, dealt with the fact that if you have legal title and equitable title, if the value was over $21, you had judicial capacity of a jury of peers in the republic to resolve that. But now today, the presumption is none of the straw men have any legal title. All they are is in raw possession as tenants of property that the government has title and control of. And since you're merely an equitable tenant, what kind of rights does an equitable tenant have with someone else's property? It doesn't apply unless you come in as a creditor and make a claim. So you got to be able to understand who you are, who they are, turn this thing around so that you're the creditor, not only in equity, but in legal title, so that you've got standing to make a judicial claim, or what would account to be a judicial claim, which means today you've got to finish an administrative procedure, and if the administrative procedure in the public goes opposite to where you are in your right, you've got the opportunity for appellate review, which would reverse what they did if you do your process correctly. Okay?
We're on break for lunch.